bouncing on his shit, warrants, all types of stuff, assault with a deadly weapon, multiple fugitive from justice warrants, nuts, inflicting corporal injury on a spouse, criminal threats, and multiple robberies. Defendant also has misdemeanor convictions and an infraction involving arrest for taking a vehicle without consent during a suspended license and domestic violence incident. Defendant frauds crimes. Defendant crimes do not pertain only to violence and weapon possession. Defendant is currently under investigation for fraudulently applying for FEMA benefits by claiming to be a re-enter a property in Pasadena, California, destroyed in Eaton fire in January 2020. Moreover, in the digital devices seized during his previous arrest, defendant was in possession of multiple social security numbers, addresses, and other personal identifying information that he had bought on WhatsApp. Oh my God. Defendant, they proving it on you right there. Damn. Defendant even had a photograph of a driver's license with his photograph but a different name on it and a different address and state. Defendant was detained based on the risk of flight and danger. So on March 19, 2025, this is the point why he's detained. The court ordered defendant detained pending the trial based on the risk of non-appearance and the danger to their community, bro. So he man, Bricc, come on, man. If he out, let me know, because the shit was at 9 o'clock. So we should know he's out. Yo, bro, with all of this, they're not. They're not. This court found detention to be appropriate. They found it to be appropriate based on one, the defendant's history and characteristic. That's all they blame it on, including his criminal record of fugitive arrest and violating parole and probation condition, as well as insufficient bail resources, which he's saying this is the reason why he's going for trying to get the bail, because he has more bail resources now, right? But this all above this is still jamming him up though, regardless of the fact. Defendant's safety risk is due to the nature of the seriousness of the instant charges and the criminal history, which includes numerous convictions, some of which were violent. Argument: legal standards for pretrial detention. Defendant must be detained pending trial where no condition or combination of conditions will reasonably assure the appearance of the persons as required and safety of any other persons of the community, as in 18. Detention is thus appropriate for the defendant who is either a danger to the community or a flight. United States versus, then they go into the purpose of this case right here, where this person need to be. The Bail Reform Act mandates that individualized evaluation guided by the factors articulated in 3142G, United States versus Diaz-Hernandez, another case which they state, in the nature of the circumstances of the offense charged, including whether the offense is a crime of violence, the weight of the evidence against the defendant, defendant's character, physical and mental conditions, family and community ties, past conduct, history relating to drug or alcohol abuse, criminal history, and the nature of the seriousness of the danger to any person or to the community that would be posed by the defendant's release.